Hello and welcome. I am Marc Blatstein, the physician founder of Physician Pre-Sentence Report Service. We are physician prison consultants. We're doctors. My phone number is 240-888-7778, as you can see up top, along with my email address. This video, YouTube, is going to be on FBI DOJ's criminal enforcement, which includes here telemedicine, opioids, and the crucial importance of documentation. Because if it's not specific, and the Department of Justice is looking at you, it probably wasn't done in their eyes, even if you did it. And so let's get started. The topics I'm going to cover here are going to be artificial intelligence, which is now the Department of Justice's tool of choice. Preparation, acknowledge the impact of your indictment. Pill mills will cover healthcare fraud, distribution of opioids and other controlled substances. And then the Department of Justice is expanding from their wins of 2025. So fraud enforcement isn't slowing down. It's gearing up, and it's going to go into overdrive with their successes into 2026. Artificial intelligence. This is the DOJ's top choice, and it's because it doesn't need sleep. It doesn't need to be monitored. It's constantly data mining, and it's looking 24/7, 365. And so if, in fact, depending on how the Department of Justice has their system set up, this is almost, if not better, than their analytics that they've been using in the past. This is their multi-agent artificial intelligence, and it's not a future concept anymore. It's an operational shift in how businesses should be expected to review. So you need to be prepared. How it works is that rather than deploying a single AI system, organizations are moving toward coordinated networks of specialized agents, individual AIs that can independently act, collaborate, and adapt in real time. That's pretty big. I mean, 24/7, 365. And if the artificial intelligence is this organized, it's a very big deal, whether you're in medicine or not. If you're deciding to go to trial or plea, a little bit of housekeeping, everything I have here, if you go to my blog online, and where there's a highlight here, it goes to a YouTube that explains what I'm talking about. But whether you go to trial or plea, there is no right or wrong answer. This is a strategic decision that you and your attorneys have made. And my only thing that I can contribute as a non-attorney is that you don't want to aggravate the judge or the court. Because in case you don't win and you're not successful, you have to go back to that same court, that same judge for sentencing. So you need them for leniency. What are you to do? What can you do? Preparation for your pre-sentence interview starts ASAP. And what's the pre-sentence interview? The pre-sentence interview is before you meet the probation officer who learns everything about you above what is in your charges and your indictment. There's a litany of things to be prepared for. It's not that as simple as fill in the blank. You really have to be prepared because once you have the interview, or if you are given a form, sometimes the probation officers email these templates to the attorney and then gives it to you to fill in. Don't fill it in, because once it's filled out, it's done. I would copy and paste it and begin to do it that way, so that at least it's not the original you're working on. But I'm going to regress. As soon as you hear that the FBI is asking questions, their case against you is mostly complete. And so that's that strategic decision between you and counsel. First, you need to get an attorney who has real life experience with cases like yours that he's practiced or she's practiced within federal court. Second, if prison's unavoidable, preparing for this interview, the pre-sentence interview, is crucial. This is why people who are inmates call the pre-sentence report, which comes out of the interview, as the inmate's Bible. And so what I do, how to prepare for the prisoner, the pre-sentence interview, is you need to have, as part of this preparation right now, the Department of Justice has done a favor. They've announced to the world that you're America's most wanted. You're the bad guy or girl or gal. And so that indictment is out there. And unless you do something to humanize yourself to the judge is going to be left to sentence you based on that indictment. Full stop. The four corners of that indictment and the four corners of your pre-sentence report will mirror one another, and you just don't look good in their eyes. And so you need to be able to begin to think about drafting what would be called a compelling autobiographical backstory or narrative. And it's a very big deal. And it takes a long time to do, depending on the complications of your case. It's only one part of preparing. Next is that you want to have this all done before you get to the pre-sentence interview, so that when you provide the documentation, there's a plethora of things you'll need to pull together, you want this to be included in the pre-sentence interview and then into the pre-sentence report. as well as you're actually allowed to make a BOP placement request to the court or to the judge. It can start with a nice conversation with the probation officer. But if you think about it in a way that the probation officers who are doing this do the same thing every day with everyone. And so if how can you stand out to the probation officer? And one way is to provide all the documentation that they need, plus what we recommend, organized, spell checked, collated, so that they can get this information ahead before you meet. This does several things. First of all, it allows the probation officer that when you meet, they can get to know who you are personally at the interview. Makes sense. Second is that they probably haven't gotten all the information from clients or defendants in a organized one file that they can go through and fill out their pre-sentence report worksheet, pre-sentence interview worksheet before. And if they have, it's rare. So they're going to potentially respect the fact that you respected their time and you're taking this seriously. Will you have a choice between a minimum federal prison camp, freestanding, or a minimum satellite camp? What's the difference? There are differences. A satellite camp, both are minimum. A satellite camp is attached to a higher security facility. So on the plus side, there may be more programs that are available, but because it's attached to a higher security facility, it may be that there's a higher degree of tension among guards and then among individuals just due to the proximity to the higher security location. A freestanding minimum federal prison camp, it's not attached to anything. And so while there may not be as many first step back programs, and I'm not saying that there'll be more or less, but that little bit of extra, stress, if you will, that comes in the environment that you can't really put your finger on, that won't be there as much. Aside from other advice from other federal judges, when to start preparing for sentencing is yesterday. This is Mark Bennett, federal judge. Including your personal narrative in your pre-sentence report is a great idea because it lets the judge know who you are because it's included in the pre-sentence report. Acknowledging the impact of your indictment. There's this comes with or is included in your compelling autobiographical narrative. So judges know that crimes don't happen in a vacuum. What were your reasons? Help them understand who you are. And the only real way to do that is through your backstory, your history. Your goal is to have this narrative humanize you to the judge. Judges understand the Department of Justice, they want a conviction. The prosecutor wants prison time. Your attorney's paid to keep you out of prison or keep you free. The only person they know nothing about is you. And if you don't do anything to humanize yourself at this point to the court, to the judge, to your probation officer, then the judge is left to, sentence you based only on your indictment, where you look like America's most wanted. What has the Department of Justice been doing in this regard? So, pill mills. This is a physician who wrote narcotic prescriptions for cash after minimal examinations. He issued oxycodone, promethazine, codeine prescriptions to undercover agents. We're going to go here. I'm going to show you the original. So it's going to be page 30. And this is the actual report where fraud section year in review 2025 shows all of their successes. At the same time, they're looking to build on that for 2026. So let's see, was it 30? Let me just double check my memory. Page 30, okay. So we're looking here. Here we go. The jury convicted this physician for operating a pill mill out of his Northwest DC internal medicine practice. And just as statistics will show, the majority of pain medication is not, and pain treatments for pain is not done by actual pain management specialists. It's done by family doctors or internal medicine docs acting in family practice. Evidence showed that between May of 2021, April 2023, he wrote these prescriptions for cash. He was sentenced to 18 years, not easy, imprisonment, was ordered to pay $213,000, rather forfeit over $213,000. And this comes from pill mill operations. Next, we're going to go healthcare fraud unit, page 31. Texas pharmacist who was convicted at trial for his role in a scheme to defraud the Department of Labor through the submission of fraudulent claims for prescription compounded creams, was sentenced to 17 years, 6 months, and ordered to pay over 115 million in restitution. That's quite a bit of change, as well as 405 million in seized assets. So this is page 31. Oops, wrong one. Let's see, page 31. Here he is, 2025. Texas pharmacist who was convicted at trial for his role in a scheme to defraud the Department of Labor through the submission of fraudulent claims for prescription compound creams, was sentenced to 17 years and 6 months in prison, ordered to pay over 115 million in restitution and forfeit 405 million in seized assets. So there was a lot more. Was a lot more here. Let's see if I can pick up on it. This physician and his co-conspirators owned and operated at least 3 pharmacies in Fort Worth and Arlington, Texas, where they paid doctors millions of dollars in illegal bribes and kickbacks, referring expensive compound medications. Evidence at trial showed that these compounds were being mixed in the back rooms of the pharmacies by untrained teenagers. Not good. So that is one example. Distribution of opioids. Here's another one, page 37. Let's see, page 37. And get my mouse to cooperate. No. Oh, come on. There we go. This Pennsylvania physician was sentenced to 14 years in prison for orchestrating. His scheme involves illegal distribution of opioids and other controlled substances. He ran an in-house pharmacy that required patients to accept large quantities of medically unnecessary medications, including oxycodone, in order to obtain prescriptions. Unlicensed medical interns wrote the prescriptions under minimal supervision, creating extreme risk for addiction, overdose, and life-threatening consequences. Here, so you have, as physicians, pharmacists, you have so many years tied up in your education, in schooling. Nobody wants to tarnish their reputation and wind up facing prison, but there's whatever reasons, none of them are excuses, but a lot of this can go into the pre-sentence interview or pre-sentence report through your own personal backstory. The Department of Justice is expanding on their own wins from 2026, which I've already showed you, and right here, 2025. The fraud section isn't slowing down. They're gearing up. Expect excessive, aggressive, and possibly expanded enforcement targeting fraud tied to federal programs. However, the new fraud division is ultimately structured. The message is clear. Misuse of federal funds remains a top priority. The government will continue to rely on powerful tools like the False Claims Act to pursue companies, nonprofits, etc. Politics. Think about it. Politics now is also shaping priorities. Early signals suggest that this division could operate out of the White House with focus areas that may shift based on these same political policy agendas. That adds definite uncertainty as to how cases will be selected and pursued. Compliance is really probably the most important thing you can do to protect yourself. Organizations receiving federal funds, especially in highly regulated sectors, should reassess internal controls, billing practices. You can't just blame billers, even if you're a CFO. Eligibility certifications and representations made to the government. So we have here, this is called the clinician.com. Healthcare risk management, in-house policy is going to be your best defense. And here we go. So it's the clinician. And so in this particular issue, they review the evolution of the False Claims Act, opioids leading to more fraudulent investigations. That's not going to stop. AI is becoming a new threat onto data security for sure, and it's going to be used by the Department of Justice to find out what you're doing. Telehealth requires scrutiny. Telehealth, as of January 2026 until the end of December 2026, has another extension where it'll still be allowed to be used, but you need to have it documented. You just can't build telehealth. Legal review and commentary, suit dismissed after mixing board certifications. And then hospitals are not immune. In this particular case, an expert nurse excluded in the neonatal injury suit. So you can be, a CEO, CFO of a hospital system. Doesn't matter. Department of Justice is an equal opportunity indicter. Timing matters. As the Department of Justice structures evolves, early engagement with counsel can help access exposure, manage parallel civil and criminal risk. They're looking to build on criminal risk in 2026 and respond strategically before issues escalate. Bottom line, if you receive federal dollars, expect scrutiny and prepare accordingly. I appreciate you taking the time to listen. I hope you have a great day and that this has been helpful. Again, thank you and stay safe.